Good morning, everybody. Today's proceedings are going to be live streamed, subject to a 15-minute delay. Those with recording devices may use them for the purpose of transmitting what they hear in the hearing room, but only after a 15-minute delay has elapsed since the event that they're reporting. Such devices may not be used for recording or photography. Mr. Barr.
Thank you, sir. Mr. Waite, just a few follow-up questions from yesterday, first of all. In relation to building legends, are you able to help us with whether Bob Lambert actually checked whether the parents of the deceased child whose identity he used had passed away? Yeah, we can't hear you, I'm afraid. We missed that answer, I'm afraid. Could you repeat it?
I don't know whether Bob Lambert used that in his legend or not.
Was the purpose of checking whether or not the deceased child's parents still alive to estimate the chances and assess the risk of someone finding them?
I suppose so, yes.
Wouldn't checking whether they were still living at the address on the birth certificate also have helped towards the same aim?
I can see it could have done, yes.
Are you sure that the addresses were not checked?
No, I'm not absolutely sure, no.
Can I move now to the question of CND? And I asked you some questions yesterday about the targeting of CND. I'd like to call up, please, document 29299. This is a security service note for file about a liaison meeting which occurred on the 22nd of November 1984. And if we look at paragraphs 2 and 3, which deal with HN 65 and HN 88, please. In relation to HN 65, it says, his last major activity will be to attend the CND National Conference at Sheffield, 23rd to 25th of November. I handed over the brief I discovered that this will also be useful for HN 88, who is attending the conference. In the light of HN 88's apparent shortage of work, I again questioned whether he might be better moved into SWP, particularly as he is close to the headquarters. Tony Waite agreed that he was currently somewhat underemployed, but is set on making him HN 65's successor in CND. Do you have any reason to doubt the accuracy of that written record?
No, I don't believe I have.
The inquiry is aware that HN 88 certainly reported on CND a good deal, especially so towards the end of his deployment. Is it in fact correct that HN 88's deployment involved as at least a significant strand at targeting CND?
I can't remember now, but it sounds as if it would, yes.
Yesterday I was asking you about how much consideration you gave to Jackie and Mrs. Lambert, and you gave an answer which I'm going to read out to you. It's been pointed out to me that it's a little ambiguous. Once I've read it, the question is going to be, have you ever met the deceived woman, Jackie? The answer you gave yesterday was, I must confess that I do regret not giving more support to, certainly to Jackie, his wife, who I did know, and it's unfortunate thing, but I did not associate the man with what you've been telling me this afternoon. So did you ever meet the woman who Bob Lambert deceived and we call Jackie?
I don't believe I ever have, no.
Were you ever aware at any point, either during your career in the police or indeed afterwards, of any thought being given by the Metropolitan Police Service to informing Jackie about Bob Lambert's true identity and providing maintenance to their child, TBS?
I don't think they did.
Can I move now to the question of the Lambert marriage? You have said in your witness statement that it was a good marriage and that you did not think that his affair impinged on it. Could you help explain why it is that you think Bob Lambert deceiving Jackie whilst undercover did not affect his marriage?
I think she realised that it shouldn't. Most of the other officers as well were married, and some were having affairs, I know. But it didn't affect a good marriage because they accepted it as part of the work. And as far as Bob Lambert's wife, who I met on a few social occasions, I don't think he ever bothered her. And she probably didn't think he would go astray the way he did.
Just to clarify, first of all, which other officers were having affairs in their undercover identities?
Well, you have told me the names of the people, and I can't do that offhand now, but I didn't know at the time.
And in terms of Mrs. Lambert, to the best of your knowledge, did she know at the time?
Don't know that.
Did you ever say anything to her about the affair?
No.
Or the risk of undercover police officers engaging in sexual activity undercover?
I could have said something about the stresses and strains we put their marriage under, but if we let them come into SDS, yes, but specifically, no.
Can you help us with what you might have alluded to?
I don't think I can, other than say, if you have a good marriage, it'll survive these rough waters.
So can I take it that your earlier answer was an assumption that if a wife knew or suspected, she would wear it for the job?
I think mostly they did. I don't think most of them were aware their husbands were having affairs, if they were. And lots of them weren't.
There were dinner dances and Christmas parties for the SDS personnel and their partners, weren't there?
Yes.
And did Mrs. Lambert attend those?
Yes.
And so you were in the position, after Bob Lambert had told you that he might have fathered a child, of attending those socials with Mrs. Lambert, knowing her husband had been having sex with an activist.
I can't remember the time scale now as to when if I saw Bob Lambert's wife after we knew that he had an affair. I can't remember.
It was fairly early on in his deployment.
I probably met her and didn't mention it, no.
How did you feel about that?
I felt it was one of the problems with being in SDS.
How could you look her in the eye?
I'm a policeman.
Do you still consider that Bob Lambert deserved his commendation?
Yes, he was providing good information.
Notwithstanding sexually deceiving 4 women?
I wasn't aware of the 4 women. It was just his wife. We knew by then that he was deceived.
My question is directed at your thinking now. Do you still consider that Bob Lambert deserved his commendation?
Yes, his work was good.
I'm going to move now to another woman that Bob Lambert deceived. We call her RLC. If you need to consult the cipher list, you can do so.
Thank you so much. Yeah. Yes, I've seen that now, thank you.
In your witness statement, you say that you had no knowledge of Bob Lambert's sexual activity with RLC. Is that still your recollection?
Yes, it is.
Could we have now document 748881 up, please? This is going back to your first witness statement. Page 155, please. Paragraph 413, if we could have that expanded. I am referred to an extract from HN 19's inquiry witness statement in which he recounts, quote, in around November 1985, I was invited to give a presentation on the SDS and tradecraft generally to members of security services. Detective Chief Inspector Waite was in attendance. As a light-hearted introduction to my presentation, DCI Waite made a comment to the effect that one of our animal people had been involved in a pregnancy scare, but the fact of the child being mixed race rules out the officer entirely. He did not name the officer. I was rather surprised to hear this. I did not know, and still do not know, to whom he was referring, but given the reference to animal people, I assumed that he was not referring to HN 67. And that's the end of the quotation. I have vague memories of such a presentation to one of the intelligence agencies, I cannot remember which. I cannot recall making the comment about the pregnancy scare or a mixed-race child, so I am unable to assist further in this regard. Do you dispute HN 19's recollection?
Can't dispute it because I can't remember all the speeches that were said, all the conversations that were held. I can't remember them now.
Can I take it from that you might have made such a joke?
I've been known for making poor jokes in the past.
Would there have been any factual basis for the racial aspect of what
I cannot remember.
Of what HN 19 remembers?
Sorry, no, I can't remember.
This was after Jackie had fallen pregnant, significantly after Jackie had fallen pregnant. If you did say what HN 19 recalls you saying, would that have been based on your knowledge of what Bob Lambert had done?
I assume it would, yes.
And if it were to be suggested that this evidences a permissive attitude to sexual relationships whilst officers were undercover, Would you agree?
I think this was just a meeting with the SDS, with Box 500, and it was light-hearted, as the statement maker said.
I think the point is, if the boss of the unit is making jokes about it, it generates an atmosphere in which the issue would not be taken very seriously. Would you agree?
I can't remember what I said now.
Assuming it was said, would you agree with that proposition?
Yes, I think I would.
We can take that document down now, thank you. You said in evidence yesterday, when I was asking you some questions about the woman that we call Lizzie, the woman who was deceived by Mike Chitty, you said that you were told very, very rarely about sexual activity between undercover police officers and members of the public. Can I just be clear, were there any other instances other than Bob Lambert's approach to you about sexual activity between undercover police officers and members of the public?
I can't recall any other person coming to me and telling me they've been having sexual relationships.
Were any sexual advances or other sexual issues brought to your attention?
No, I don't believe they were.
When you were meeting with your undercover police officers in the safe house at the bi-weekly meetings, was there any discussion of sexual matters?
I don't remember any such conversation.
Was anything said about the relative merits in terms of attractiveness of female activists?
I don't remember that either.
Might that have happened?
It's possible.
Were any written records made of your discussions with undercover police officers?
You know, I can't remember now.
Was a written record normally made of the bi-weekly meetings?
No.
In your witness statement, you tell us that no discreditable conduct occurred when you were an SDS manager.
Yeah.
That goes too far, doesn't it? The reality was there was discreditable conduct. There may be a question about how much you knew about it at the time, but would you agree that you now know that there was a significant amount of discreditable conduct whilst you were the DCI of the SDS?
I now know, but I did not know at the time.
But you did know about Bob Lambert, didn't you?
I did know about Bob Lambert, yes. He was a solitary case.
Do you remain of the view that that was not discreditable?
I had never given it thought before, but I don't think it was. If it was consensual and done outside the job's working hours.
We do know that a lot of Bob Lambert's interactions with Jackie were in working hours and paid for by the taxpayer. Does that change your view? I beg your pardon?
I wasn't aware of that, I'm sorry.
Does that change your view?
I think it does slightly, yes.
When you say slightly, from too discreditable?
I don't think it really was. They were doing a job and they did what they thought was necessary.
I'm going to put two more passages from the Commissioner's opening statement for this part of the inquiry to you. In each case, I'm going to stop and then ask you whether you align yourself with the apology now. First, at least 9 undercover officers in Tranche 2 engaged in deceitful sexual relationships whilst they were deployed. This was completely unacceptable. So too was the failure of their managers to identify and prevent those relationships from happening. The MPS apologises to the women affected and to the public for these failings and for the wider culture of sexism and misogyny which allowed them to happen. As set out below, it is committed to eradicating all forms of discrimination and to ensuring that undercover policing, like all other policing, is conducted and held to the highest professional standards. To what extent do you agree with that?
I think I agree with it wholeheartedly now.
The MPS accepts that these sexual relationships occurred and that further relationships will be examined during the inquiry's later investigations of T2, T3 and T4. Such conduct was a gross violation of the women's privacy and human rights. It was abusive, deceitful, manipulative and wrong. The MPS apologises again, unreservedly, to the women whose lives have been and continue to be affected. The MPS also apologises to the wives, partners and families who have also been harmed by the misconduct of the UCOs and the failure by the SDS's managers and senior MPSB management to prevent that misconduct. To what extent do you align yourself with that?
I think I'd go along with what he said, what the Commissioner says, yes.
Going to move now to a completely different topic, and that is the instances in which UCOs under your command became involved with the criminal justice system. First of all, can I start with an incident in which HN19 was arrested and cautioned? Do you need to remind yourself as to who HN19 was?
Yes, I do, thank you. Yes, yeah.
Could we have up, please, 526786, tab B20, sir? If we expand that, it's a minute sheet, and you sign minute 2, which is from you to the DCS of S Squad. As you are aware, Stephen Shearing is the alias of DS HN19. The circumstances of his arrest were that on the 11th of September, he was directed with 2 women members of his group to post bills in the vicinity of the Elephant and Castle. They were doing this when they were arrested. Later, they were taken to Southwark Police Station where they were released after being cautioned. The arrest has not embarrassed DSHN19, and in fact it seems likely that it will, if anything, enhance his standing within his group. He is, as you know, a very experienced and professional officer, and there is clearly no need for him to receive words of advice as to the requirement for him to be cautious in the future. His true identity was not revealed to the police at Southwark, and there is no question of any further action on their part. This was a trivial incident and no action would seem to be necessary on our part. Is it likely that this record is factually accurate?
I would imagine so.
And so we can take it that HN19 was arrested and cautioned with others?
With these 2 other women, yes. That sounds reasonable.
Was any consideration given to a UCO receiving a caution in a cover name?
We had considered it, yes.
And what was your thinking?
I'm not sure now.
Would the use of the word trivial have come into play? Did you regard it as trivial?
It was only posting.
Did you know about to the fact that HN19 was going to go bill posting beforehand or not?
I don't believe I did know.
And was that a matter of concern to you, or was that within the ambit of what the officers were permitted to do?
It's what the officers were permitted to do.
We can see from this minute that you were reporting it up the chain of command. Are you able to help us with how far up the chain of command issues like this would normally go?
I should imagine the commander, but I don't know on this occasion.
Was any consideration given to permitting fellow suspects to consent to being cautioned in ignorance of the fact that the man that they had been committing the crime with was in fact a police officer?
I don't think I can answer that.
Well, was any consideration given to getting in touch with the local police and persuading them to drop the matter entirely?
We did do informal court on one occasion, I can remember. And it's possible we were told that the police and the local police that we knew the man, and he was one of ours.
Well, this particular minute in relation to this particular instance says, it's the penultimate paragraph, his true identity was not revealed to the police at Southwark, and there is no question of any further action on their part.
It was clearly a decision at the time on this individual case. Each case would be looked at individually.
Were these cautions allowed to happen in order to maintain the operational security of the SDS?
Yes, I believe it was.
Could we take that down now? Going to move to the arrest of Mike Chitty in 1985 at a British Union against vivisection demonstration. Could we have up 526787? Could we go, it's tab B29, sir. Could we go to page 6, first of all? This is a report about the arrest of Chitty, and if we look at paragraph 1, we will see a factual summary. On the 4th of November 1984, a demonstration organised by the British Union for the Abolition of Vivisection took place in Leyden Street, East 1, which resulted in the arrest of 18 animal activists. Their protest is directed against the owners of a building at 10B Leyden Street, East 1, in which live chickens are killed at customers' request, allegedly in an inhumane manner. Among those arrested was Detective Sergeant Michael Chitty of the Special Demonstration Squad under his cover name Michael Blake. All prisoners were taken to Arbour Square Police Station at about 10:45 hours, and all were charged with obstructing Chief Superintendent Lintott in the execution of his duty, contrary to Section 51, subsection 3 of the Police Act 1964. D.S. Chitty was bailed to appear at Thames Magistrates Court at 10 a.m. on Monday the 5th of November 1984. The 18 defendants all answered to their bail and pleaded not guilty to the charge. They were further remanded on bail until the 5th of December 1984 on condition that they do not frequent Leyden Street, Bell Lane and Middlesex Street, East 1, between the hours of 8 a.m. and 3 p.m. on Sundays until they next appear at Thames Court. Could we go to the next paragraph? I attended Arbour Square Police Station at 11 a.m. to liaise with Chief Superintendent Lintott during Detective Sergeant Chitty's detention. I informed Mr. Lintott that Blake was in fact a special branch officer working undercover, and I spoke to him with a view to avoiding the risk of Blake being compromised. All defendants refused to allow fingerprints to be taken, and no subsequent court order was requested. So this is an example of something being said by the SDS to the arresting officer, isn't it?
Yes, it does, yes.
And it appears that this is signed by your detective inspector at the time. Can you recall anything that would help us shed further light on what was said to the police at the time?
No, I'm afraid I can't.
And if we go now to page 4, please. And if we could look further up the page. Thank you. This is a report, 4th of January 1985. You will see that paragraph 1 summarises the facts, and then paragraph 2 records Detective Sergeant Chitty pleaded guilty to the charges against him and agreed to be bound over in the sum of £150 to be of good behaviour for 12 months, and that's signed by you. There is nothing in the paperwork to suggest that the prosecution or the court was told anything about Mike Chitty's real identity. Are you able to help us now as to whether or not the prosecution was told anything?
No, I'm not able to do that.
And the court?
I'm not sure. I don't know. I can't remember this case that intimately.
And so it would appear on the face of the papers that people were convicted without knowing that there was a police officer in their midst.
That would be true.
Was any thought given to that?
I don't believe there was.
Was any thought given to the creation of a criminal record in the cover name of the officer?
I really can't remember now at this time.
A name that was derived from that of a deceased child. Did that ever factor in the thinking?
Not that I can remember, no.
Shouldn't the court have been told what was going on?
In retrospect, I think we could have done, yes.
When you say in retrospect, if you had addressed your mind to the issue at the time, wasn't that the correct thing to have done?
We did do that subsequently in another case. We told the court. I can't remember the details of this one. It was Mike Chitty's conviction.
We're aware of a case when an officer was convicted for drink driving and the court was told.
Yes.
But that's not a case that involved activists. The distinction here is it's a case where he's appearing as one of very many co-defendants. Might that have explained the difference?
It could have done.
Could we take this down now, please? I want to move now to the question of Chris Bailey's arrest at Roehampton following an attack on St Marcus's Butchers on the 26th of September 1985. I'm going to call up, first of all, 28452, tab B65, sir. This is a report dated the 1st of October 1985. It's one of Bob Lambert's reports. We see from his nominal at the bottom right of the page. Could we look at paragraph 2, please? It reads, at about 1 a.m. on Thursday, the 26th of September 1985, members of Anarchists for Animals, AFA, carried out a second attack on St Marcus, not St Monkton as previously reported, butcher's shop in Roehampton. On this occasion, a slab of concrete was thrown through the shop window, and RCM, and I can tell you now that RCM is the activist Chris Bailey, was arrested at the scene for his part in the crime. Now, we've had oral evidence from Bob Lambert about this incident, and his evidence was to the effect that he was the driver, effectively the getaway driver on this occasion. Can you help us with why Mr. Lambert's involvement, even in his cover identity, is not recorded in this report?
No, I can't account for that.
Might it have been for operational security reasons?
It sounds the most likely reason, yes.
Did you know that Bob Lambert was involved in this incident?
I can't recall that now.
Can you recall whether you were told about it afterwards?
I would assume I was, but I can't remember that either now.
Are you able to assist us with whether any other manager was made aware of Bob Lambert's involvement in this incident?
No, I can't.
We now know that Mr. Bailey went on to be convicted as a result of this attack. Are you able to help us with whether any thought was given to informing the court that Mr. Lambert, an undercover police officer, was involved in events?
No, I'm afraid I can't recall any of this.
Is it likely, given the overarching importance of operational security, that the court was not told?
I don't know.
Well, if the court had been told, presumably there would have been a written record.
I would have thought that would have been normal practice, yes, but I can't remember this particular incident at all.
And there would have been a debate, no doubt, about the consequences of disclosing the existence of an undercover officer mid-deployment.
Probably, yes.
That's something that significant that you might well remember it today.
I don't remember it.
If we assume that the court was not told, does it concern you that a man was convicted at a trial in which the court was ignorant of the fact an undercover police officer was the getaway driver?
Yes.
Shouldn't the court have been told?
I find it's very difficult after this big lapse of years to remember what was discussed at the time.
Doesn't this case highlight the dilemma that we discussed yesterday? If you have a long-term intelligence gathering officer in an animal rights movement who becomes involved in criminal activity, there's a problem. You either have to disclose the officer's identity or you risk a miscarriage of justice.
We were always very insistent on men not getting involved in criminal activity.
But it appears...
I imagine that was said at the time, but I can't remember. It's too long ago.
Can we take that down now and move to Bob Lambert's arrest and prosecution at Murray's Meat Market on the 7th of December 1985? Can we start with 526788, please? It's tab B99, sir. And can we go, first of all, to page 9. This is a report dated the 10th of December 1985 with the title Arrest of Detective Sergeant B. Lambert. If we look at paragraph 1 and 2, first of all, please. Whilst taking part in a demonstration outside Brixton Meat Market, Atlantic Road, Southwest 9, on Saturday the 7th of December 1985 at 11:45 a.m, Detective Sergeant Lambert, in his role as a member of Anarchists for Animals, was arrested for obstructing the highway contrary to Section 137 Highways Act 1980. The demonstration in which he had been taking part had been designed as a protest against the sale of meat. Not unnaturally, the butchers against whom this protest was aimed objected and assaulted some of the animal activists. The arrival of police undoubtedly saved more of them being attacked. However, the police took the view that the demonstrators had caused the disturbance and arrested 5 of them. 3 for obstructing police, 1 for using abusive words, and Detective Sergeant Lambert for obstructing the highway. They were taken to Brixton Police Station, where in addition to the charges already mentioned, they were further charged with delivering insulting leaflets, contrary to Section 5 of the Public Order Act of 1936. If I just pause there, do you have any recollection of this incident now?
Really? No, I haven't.
Could we...
Excuse me.
Take a moment.
Yeah, thank you. I have now, yeah.
Could we go down to paragraphs 5 and 6, please? At 9:30 a.m. on Sunday, the 8th of December, I saw Inspector TN43, the officer who had been responsible for charging Detective Sergeant Lambert. I told him of our interest in the matter, but did not inform him of Detective Sergeant Lambert's true identity, he having been charged in his false name of Mark Robert Charles Robinson. Inspector TN43 believes that Robinson is a very good informant who we are anxious to protect. He assured me that no further charges were intended and promised his full cooperation. So another case in which the police were told at least something. Do you accept that?
I accept that, yes.
Yeah. Albeit not the whole truth.
I really can't remember these individual cases so many years ago.
Okay, well, we'll continue refreshing your memory if we can from the document. Paragraph 6, at Camberwell Green Magistrates Court on Monday the 9th of December, Detective Sergeant Lambert with 3 other defendants, a further one is due to appear on Wednesday the 12th of December, pleaded not guilty to the charges against them. They were released on bail with the only condition of which was that none of them should go within 50 yards of the junction of Brixton Road and Electric Avenue. They are to appear again at Camberwell Magistrates Court at 10 a.m. on Monday the 6th of January 1985. And if we can go over the page to paragraph 8, please. On Monday the 9th of December, Chief Superintendent Webber was seen at Brixton Police Station and informed of Mark Robert Charles Robinson's true identity. He understood our concern and agreed to give any help he could. He promised to keep the identity and our involvement to himself. This report is signed by you. Can you help us as to whether it was you who spoke to Chief Superintendent Webber?
No, I can't do that.
And can we take it that if there was he'd promised to keep the identity and the SDS's involvement to himself, that the information would have not got to the court?
I don't know. I can't remember this case that intimately, and I can't remember the argument.
Could we go now in the file to page 3, please? This is a minute by Chief Superintendent David Golding, dated the 10th of December. And if we look at the last 2 paragraphs of the text, this arrest, though unfortunate, will probably enhance Detective Sergeant Lambert's standing within the animal movement, and in the long term it should prove to be useful. Was it generally the sentiment that if an undercover officer was arrested in the company of activists and had a brush with the criminal justice system, it had some beneficial effect to the deployment?
I always imagined so, yes.
The minute goes on to read, I have directed DCI Waite to continue to monitor this case personally. I understand the difficulties you're having with your memory, but would it be fair to assume that if the Chief Superintendent had asked you to monitor the case personally, it is likely that you went on to do so?
Yes.
Could we go to page 7, please? This is a report, 14th of January 1986, signed by your DI, and it's about DS Lambert's court appearance. On Saturday, the 7th of December 1985, Detective Sergeant Robert Lambert, in his cover identity of Mark Robert Charles Robinson, was arrested with 4 other animal activists whilst taking part in a demonstration outside Murray's Meat Market, Brixton. And then it gives a reference to the earlier report. Following his remand at Camberwell Magistrates Court on the 9th of December, this case was adjourned until the 6th of January 1986. On that date, DS Lambert appeared with the following 4 co-defendants, who are then listed. And if we could go down, sets out in paragraph 2 the charges and the pleas, and paragraph 3, which I'm more interested for these purposes, all defendants are being legally represented by Privacy, a barrister who has been instructed by Privacy of Messrs Mildred and Beaumont, 299B, Lavender Hill, SW11. Can you recall, was that firm one of the firms that did a lot of defendant work for activists?
I can't confirm or deny that at this stage. It's too long ago, I can't remember.
Was any consideration given to the propriety of an undercover police officer being represented in court jointly with members of the public?
I can't remember that any such a discussion took place.
Is it likely that that's something you gave your attention to or not?
I imagine I would have done at the time, yes.
Isn't there a problem with having an undercover police officer listening in and receiving legal advice with co-defendants?
I can see that now, yes.
Did that problem occur to you at the time?
I don't believe it did, but I can't remember the details of this case.
Would you accept that that involves a breach of legal professional privilege?
I would accept that, yes.
Could we take this document down now, please, and have 747118 up, please? There's a little bit of detail involved in the next two documents we're looking at. This is a report about events at the trial. Could we go first of all to the end of the document to see whose report it is? It's signed by Detective Constable HN4. If you need to refresh your memory as to who HN4 is, please consult the...
Yeah.
Although HN4 did serve in the SDS, our present understanding is that at the time this report was made, he was not serving in the SDS. If we could look first of all at paragraph 1. On Monday, the 24th of February 1986, at Camberwell Green Magistrates Court, 5 members of Anarchists for Animals, Stephen Curtis, Privacy, Mark Robinson, Geoffrey Shepherd, and George, appeared to answer various charges arising from a demonstration outside Murray's Meat Market on Saturday, the 7th of December. If we go now to paragraph 3. After a lengthy submission from the defence, the magistrate, Sir Brian Roberts, grudgingly consented to have each of the defendants tried separately before different justices. The case of Privacy was to go ahead on this occasion. If we could go now to paragraph 4. At the end of the prosecution case against Privacy, the defence asked the magistrate to consider whether the leaflets distributed outside Murray's Meat Market and the subject of a charge under Section 5B Public Order Act 1936 were in fact insulting. Privacy ruled that although the drawing of a butcher's dissecting a human baby was insulting, the leaflet had to be taken as a whole, and that the text qualified the diagram and rendered it no more than distasteful. He therefore dismissed the charge in relation to this article. In Privacy's defence to the second charge of using abusive words, both Robinson and Shepherd gave evidence, and RCM, who I can tell you is Chris Bailey, a well-known animal rights supporter, was also to have been called, but the lunch break interceded. After this interval, both counsel entered the court discussing bindovers. This was put to each of the 5 defendants, who all agreed to be bound over to keep the peace for 12 months in the sum of £50. We can see from that report that Mr. Robinson, Detective Sergeant Robinson as he then was, gave evidence as a defence witness, didn't he?
Yeah, I can see that from the report, yes.
Is that something you would have known at the time?
I assume I would have done at the time.
And it's something you would have known about because you'd seen this report, or because Bob Lambert would have told you, or possibly both?
Probably both.
Can we take that document down now and have up the document 526788? Again, that's tab B99, sir. Could we this time go to page 5? This is a report by you, dated the 28th of February 1986. Could we look at paragraphs 1 and 2, please? This report is about the court proceedings. On Monday, the 24th of February 1986, D.S. Lambert, charged as Bob Robinson, appeared at Camberwell Green Magistrates Court charged with obstructing the highway and distributing an offensive leaflet. George Privacy, Steve Curtis and Jeff Shepherd were co-defendants sharing the second charge, but facing various charges under the Metropolitan Police Act. All 5 were represented by Privacy, a barrister instructed by Privacy. Privacy's case was the first to be heard, and Shepherd gave evidence on his behalf. At lunchtime, the magistrate decided that there was no case to answer in respect of the offensive leaflet charge, and therefore the same decision was recorded in respect of the 4 other defendants. Police then offered no evidence on the other charges, and all 5 defendants were bound over in the sum of £50 to keep the peace for 12 months. Now, it's evident, isn't it, comparing your summary here of the facts with the report that we've just looked at, that there is both a minor and a major discrepancy. The minor discrepancy is as to the chronology, in that the submission of no case to answer was made before lunch, and it was the bind-over that happened immediately after lunch. Do you agree?
It would appear so from the documents you've shown me.
The more significant discrepancy for our purposes is this account omits the fact that Bob Robinson gave evidence on behalf of the defendant, doesn't it?
Yes.
You were monitoring this case personally, not least because you'd been asked to do so. Why did you omit from this report the fact that Lambert gave evidence in his undercover identity?
I don't know now. I cannot remember.
Is it something that you wish to conceal from your superiors?
I don't know. I don't think so.
Is it something that you did not want to commit to a written record?
I don't know what my motives were at the time.
Could we go to page 4, please? This is the minute from Chief Superintendent Parker, dated the 28th of February 1986, about the court proceedings. The case against Detective Sergeant Lambert was heard at Camberwell Green Magistrates Court on Monday, the 24th of February. He was bound over to keep the peace for 12 months. This was a good result, as it will have enhanced his standing amongst the anarchists with whom he associated, whilst at the same time allowing him not to take part in those actions at which there is a chance of arrests should he so wish. Detective Sergeant Lambert has behaved very sensibly throughout this difficult time, and he is to be commended for his professional attitude. Were you aware that your senior managers were pleased with the outcome?
I think I must have been. I can't remember.
What had happened, though, was that the court had been misled as to the true identity of a witness who had given evidence to them, hadn't it?
It would appear so in retrospect.
And so was the defendant.
Yes.
So this wasn't a good result, was it?
It wasn't the terms that the Chief Superintendent Parker relates.
I beg your pardon?
was a good result. It did enhance Bob Robinson's position.
A good result for the operational security of the SDS and its continuing operation. A bad result for the operation of justice.
Probably, yes.
Did you, I appreciate you're struggling with your recollection, so if you'd rather me ask, would you, take the question as would you have, you can make that clear, but did you or would you have addressed your mind to that problem?
I don't believe I would, no.
Could we take that document down now, please? And I want to move to another incident, a request that Bob Lambert give evidence for Steve Curtis in the spring of 1986. Could we start with 28389, please? This is tab B84, sir. This is a report dated the 23rd of May, 1986. It's entitled at the side, Bob Robinson, Court Appearance. You have signed the report. Can we look first of all at paragraph 1? It has been learned from a secret and reliable source that on Saturday the 19th of April 1986, some anarchist members of London Greenpeace took part in a campaign for nuclear disarmament, CND demonstration, against the American airstrike in Libya, in Grosvenor Square. At approximately 2:45 p.m, there was disorder on the south side of the square when some demonstrators sought to remove crowd control barriers. Steve Curtis, a member of London Greenpeace and a regular troublemaker at public order events, was amongst this number. He was arrested by uniformed police at the scene and subsequently charged with threatening behaviour. Could we move now to paragraph 2? He is due to appear at Bow Street Magistrates Court at 2 p.m. on Tuesday, the 1st of July 1986, and intends to plead not guilty. Bob Robinson, also of London Greenpeace, is one of 3 comrades who have been asked to appear as defence witnesses. Curtis is usually represented in court by Privacy of Mildred and Beaumont, or a barrister instructed by her, and it is understood that this will again be the case. His defence will be that he was a peaceful protester wrongly identified by police as an agitator. Defence witnesses will give evidence confirming his sober behaviour during the protest. We can see immediately there a distinction between this case and the last one we were looking at, because the fact that Bob Robinson might be involved as a defence witness is clearly included in the report. Are you able to help us at all as to why it was included in this report and not the report in the last case?
No, I'm afraid I can't help on this. I cannot remember it that intimately.
Could we take this document down now, please, and have up 731080, tab B83, sir. This is a short memorandum dated the 23rd of May 1986, signed by you. Could we look at paragraph 2, please? It's about the same incident. It would seem to be necessary for Detective Sergeant Lambert to comply with this request from his comrade Steve Curtis. To fail to do so would be damaging to his credibility within his group. It is believed that such an appearance at court would not pose any special problems. Can we take it from those words that you were not thinking in terms of the impact on the administration of justice?
That's quite right, yes.
And if we could take that down and go to 731079, that's tab B85, sir. This is a minute sheet. Can we start with minute 1, please? Sorry, not paragraph 1, the whole of the first minute. It's from, starting from Commander Operations down to R. Parker, Chief Superintendent, please. Thank you. This is a minute from Chief Superintendent Parker, dated the 4th of June 86, to Commander Operations. While there would appear to be no precedent for an SDS officer to appear as a defence witness, I see no overriding problem for such a course of action in a minor case like this. Indeed, as DCI Waite points out, not to do so would undoubtedly damage his credibility within his group. Subject to your agreement, therefore, I will direct DS Lambert to appear at Bow Street Magistrates Court on the 1st of July and will brief him beforehand to be suitably non-controversial in what he has to say. There are 2 points I want to ask you about from that document. The first of all, it seems to... It's quite all right. It seems to confirm, doesn't it, that Chief Superintendent Parker was indeed ignorant of the fact that Bob Lambert had earlier given evidence to a court in the case that we just looked at.
Yes.
And secondly, are you able to help us as to whether or not we can take this document at face value, by which I mean it appears that Chief Superintendent Parker was not addressing his mind to the impact on the administration of justice either?
I think that must be right, yes.
If we could go now, please, to minute 2, further down the page. This goes over the page, and I can tell you it's from Commander Phelan. I feel you have not explored all the possible consequences in making your recommendations at minute 1. General Order, Section 6, Paragraph 109A, subsections 3 and 5 would apply to DS Lambert if he were to give evidence, and strictly interpreted should apply now that an approach to him has been made. Clearly, to inform all concerned, as set out in the General Order, is unacceptable. You might argue that the provisions of the General Order would not apply to Bob Robinson, but there then would be dangers if his true identity were then to be discovered later. Consider also what might happen if he were to be recognised by a police officer in court. Unlikely, but possible. It is also possible that his demeanour in court would reveal something of his police training and give rise to suspicion. So it's clear, isn't it, that Commander Phelan has some operational security reservations, doesn't he?
Yes, he did.
And some reservations about compliance with general orders.
Yes.
Goes on to say, the report at 1B shows that Steve Curtis is a regular troublemaker and implies in paragraph 1 that his arrest was justified. In paragraph 2, it is indicated that his defence will be that he was wrongly identified as an agitator and that witnesses will testify to his sober behaviour. This suggests that DS Lambert, Bob Robinson, will be required to commit perjury if he gives evidence. And if we go over the page now, please. In paragraph 2 of minute 1, you say you will brief DS Lambert to be suitably non-controversial. In my view, if he does not come up to Curtis's expectations as a witness, he could lose as much credibility as he would by not appearing. In view of the foregoing, therefore, DS Lambert must not give evidence for the defence, but should concoct some plausible, and then if we can have the rest, thank you, excuse. We can discuss this aspect further if you wish. So there is definitely a further operational security concern about the risk of losing credibility, isn't there?
Yes.
And there appears to be a concern about his officer being required to perjure himself.
Yes.
So a mix of operational and criminal justice considerations.
Yes.
Are you able to help us as to whether or not Bob Lambert actually did give evidence on behalf of Steve Curtis?
I can't remember that now.
You have explained in your witness statement that having seen these minutes, you were embarrassed, except that you were in error. Was your error the result of excessive focus on operational security at the expense of the administration of justice?
I think that would be correct, yes.
Moving now to the consequences of Commander Phelan's advice, and we can take this document down now. The consequence of Commander Phelan's advice was that Curtis was convicted, and that conviction was upheld on appeal, we know, without knowing that a man that he wanted to act as a witness was in fact an undercover police officer. The lack of disclosure to the court of that fact was itself problematic, wasn't it?
I don't know. It may have been at the time. I can't remember.
I'm asking you it at a level of abstraction, assuming the court was not told, withholding the fact that Mr. Lambert was really an undercover police officer means that justice can't be properly done, doesn't it?
I think that's probably correct, yes.
Could we have up, please, 727104? This is a Home Office circular about informants who take part in crime, dated the 12th of May, 1969. Could we go to page 2, please? And subparagraph C, that's the top of the page. The police must never commit themselves to a course which, whether to protect an informant or otherwise, will constrain them to mislead a court in any subsequent proceedings. This must always be regarded as a prime consideration when deciding whether and in what manner an informant may be used and how far, if at all, he is to be allowed to take part in an offence. If his use in the way envisaged will or is likely to result in its being impossible to protect him without subsequently misleading the court, that must be regarded as a decisive reason for his not being so used or not being protected. Were you aware of this Home Office circular?
I don't think I was.
Were you aware of the general premise that the police must never mislead a court?
Yes, I think I was.
It would appear on the face of the minutes we went through that you and two of your superiors all failed to score full marks so far as criminal justice was concerned. Is that fair?
That's a fair comment.
Could we take that document down now, please? I want to move to a completely different topic of a completely different nature. Could we have up, please, 29267, tab B82, sir? This is a security service note for file. It's on the SDS liaison file dated the 18th of April 1986. If we could have the text expanded, please. DCI Tony Waite called at 12:15 on the 16th of April to introduce Mike Barber's successor, Detective Inspector Eric Docker. After lunch, at which we were joined by F4 and the security service, newly arrived, I explained my role to Docker and invited him whenever the need arose to get in touch. Docker, whose last appointment was in the National Joint Unit, terrorism mainly Irish, struck me as being well disposed towards us, but deeper and more devious than his predecessor. Can you help us with whether or not you share that assessment of Detective Inspector Docker's character?
I think he was rather deeper than Mike Barber. Two very good men.
What about deviousness?
I can't comment on that.
Did you ever find him devious in your dealings with him?
No.
Are you able to help us with why the security service might have formed that view?
That was a brief meeting. They didn't know.
Could we take that down now, please, and move to another topic, that of senior officers' visits to the SDS? Could we have up 728977? Could we go to page 9, please? This is the 1986 annual report for the SDS, paragraph 11. On the 8th of May 1986, the field officers received a visit from Assistant Commissioner Specialist Operations J.A. Dello, CBE, and the Deputy Assistant Commissioner Mr. S.R.A. Crawshaw. The meeting took place at the West London Safe Flat, where a friendly but constructive exchange of views took place. Such visits by senior officers are welcomed by the field officers and serve to reduce their feeling of isolation from the main body of branch life, while at the same time reassuring them of the value of the SDS operation and the esteem in which they are held. You were the DCI at the time of this visit. Can you recall it?
No, I can't.
Are you able to help us in general terms with what level of interaction and communication there was between your unit and senior officers when they visited?
They were given free access to all the officers and they could interview them, talk to them if they wished.
So would it be fair to say that they had a very good idea at a level of generality as to what your unit was doing, the sorts of targets it was... I beg your pardon?
So I interrupted you, I'm sorry.
I was going to say the sort of targets that you were infiltrating and so forth.
Yes, they would have been told.
Would they have known that your officers were using deceased children's identities as part of their legends?
I don't imagine so.
Would they have been aware of sexual activity between your officers and members of the public?
I don't imagine so.
Can you recall whether there was any discussion about the risk of that occurring?
I don't believe so.
Can you help us with the level of contact that you would have had, not with the people immediately above you in the chain of command, but more senior officers of this kind of level about the SDS?
We used to try to arrange meetings with any new senior officer that was in post.
And were these people that you knew personally?
No, I didn't know them personally.
And to what extent to the best of your recollection, to what extent would they have been seeing any written material other than the annual reports and particular crises across their desk about the day-to-day running of the SDS?
They were free to see anything they wished.
My question is more directed at, in practice, how frequent was that?
Rare.
Could we take that document down now? I want to move to the topic of post-deployment counselling. In your witness statement, you recognise that your officers might have difficulties. And you say that there was a system of interviewing officers after the end of their deployments. Your evidence on paper is also that you never took part in one that you can remember. Is it still your recollection, or lack of recollection, you can't remember ever actually doing so?
My lack of recollection.
I want to put to you some of the evidence from some of the officers who served whilst you were the DCI. I'm going to put to you what it is that they have said on the issue of welfare and in particular follow-up. I'm going to start with Roger Pierce. If we could have up 747965. Page 127, please. Para 271. The managers kept an eye on me and my wife. I felt well supported in my withdrawal. I took some annual leave for quite a lengthy period after my withdrawal, I think. The managers provided support during that time as well. I think we went for a drink, my wife too. And then if we could go to page 139, paragraph 303, please. As far as I recall, I was not offered any advice or ongoing support by the SDS and/or the MPS following my withdrawal. At the time, I was satisfied by that, but on reflection years later, I do think that there should have been a more structured aftercare programme. At the time, however, it did not really exist. You went to the pub with contemporaries, talked about it, and then got on with life. Do you have any reason to doubt Roger Pierce's recollection as set out in those two paragraphs?
No, I don't.
Would you accept that it paints a picture of good informal support, but on reflection, a lack of structured support?
Yes, I think that is a fair comment.
Could we take that down now, please, and go to 743186. This is HN65. Have you refreshed your memory as to who HN65 is?
Thank you very much.
Thank you. Good. Could we go, please, to page 65, paragraph 191? I was not offered any advice or ongoing support by the SDS or MPS following the end of my deployment. It helped that I had HN126 to speak with about my experiences. It took some time to adjust to no longer being deployed. I started having particularly vivid and troubling nightmares after I stopped being a UCO. I also found it difficult to go anywhere with my family for a little while. That followed on from 4 years of deployment where I had the same issue. CND was such a large organisation that drew from such a broad cross-section of society that I felt there was a significant risk of bumping into CND members who might know me. So again, there appears to be a recollection of a lack of formal ongoing support. Do you accept that?
I do accept that, yes.
And would it be right to say that there was a particular problem if an officer had infiltrated a very large organisation and come across a lot of activists? There was a heightened risk of being recognised?
Yes, I can.
Could we take that down, please? Can we have up next HN19's statement 747710? Could we have page 86, paragraphs 228 and 229? Yes, if we could have 228 and 229 expanded, please. Thank you. I had accumulated holiday, which I took following my withdrawal from the field. I was debriefed by the security service following my deployment. I was separately debriefed by the SDS. There was no formal program of reintegration into conventional duties. When I returned to Special Branch in 1986, the head of C Squad was someone I'd worked with when he was a detective inspector. Detective Chief Inspector Short was also later my superintendent on C Squad. Familiarity with people helped. On an informal basis, I was eased back into normal duties. I do recall going back into the SDS office after my withdrawal to see Tony Waite. This was not so much for advice or support, but to be sociable. I wasn't offered any advice or ongoing support by the SDS or the MPS after my withdrawal, but I didn't see this as an omission. Would it be fair to characterise this as saying, again, there was informal support, but no formal structured support?
That would be correct, yes.
And if we take that down, and finally go to HN33's witness statement, 745970. Page 40, paragraph 158. I do not recall being offered any advice or ongoing support by the SDS or the MPS after my withdrawal, but in any event, I did not feel I needed any, so I did not seek it. So again, a lack of formal structured support. In this particular case, a phlegmatic officer perhaps who didn't need any. Is that fair?
I think that's fair, yes.
Could we take that down now, please? Having taken you through those, despite your evidence that there were interviews, there was at least an intention to hold interviews after deployments, was the ground truth, in fact, that there wasn't much, if any, formal support for your officers after they withdrew?
There was little formal support, but a lot of moral support for them.
Sorry, I didn't quite catch that.
A lot of moral support.
Moral support, but not
Used to meet them throughout the branch. They were working in the branch, and you see them on a regular basis.
But not formal meetings.
Not formal meetings, no.
So would that be a convenient time to take the morning break?
Certainly it would. We'll rise for 15 minutes. Yes.
Mr. Waite, I'd like to now ask for some reflections. First of all, about training. Do you think that formal training about the issue of sexual relationships would have helped your officers to understand how wrong it is for a serving police officer undercover to have sex with a member of the public and therefore to avoid doing so?
No, I mean, they were mature men who knew the rules. They were mostly married and know that they shouldn't have been doing these things. It didn't need reinforcing.
Isn't the difficulty with that observation that so many of the officers under your command, we now know, did enter into sexual activity with members of the public?
I'm most surprised at the numbers you told me of.
But doesn't that mean that formal training was called for to minimize the risk?
I don't think it would have made any difference.
Because these are not just to be dismissed as affairs, are they? They're not affairs. They're police officers misbehaving.
I think they're affairs.
Would you accept that more formal training for your officers and perhaps also for yourself and your fellow managers to reinforce the message that courts must not be misled would have helped to keep you on the straight and narrow?
I think that would have helped, yes.
If it would have helped in relation to misleading courts, why wouldn't it have helped in relation to avoiding improper sexual activity?
It's such a natural drive. If you put young men and young women together, you're going to get these problems.
Is that observation a reason to consider very carefully indeed whether the undercover tactic should be used at all?
No, I don't. I think we obtain good results and will help to the rest of the police force and to the security service. We've provided a good service to them.
Is the problem with that answer that it is dismissive of the impact that such deceptions have, such sexual deceptions have on the women involved?
Yes, I accept that, yes.
Would more formal training have helped to keep a focus on what intelligence was really relevant and necessary, and therefore which were appropriate targets and what should have been committed to writing in reports?
Yes, I suppose that is right.
Would more guidance or refresher training following on from Hendon in the specific context of undercover policing have helped you to make lawful decisions as to the circumstances in which your officers could, first of all, enter private property?
I don't think we ever spoke about entering private property.
No, what I'm putting to you now is, wouldn't some guidance about the circumstances in which it was lawful for an undercover officer to enter private property have been helpful to you?
Oh yes, if you get more knowledge, it must be of help.
And the same would apply so far as the taking of confidential information?
Yes, I think so, yes.
And respecting legal professional privilege?
Yes.
Can I move now to your time as Detective Chief Superintendent and head of C Squad? We know that you held that post between the 10th of November 1989 and April 1991. Can I start with your role in targeting? Presumably, as head of C Squad, you were in contact more regularly with people higher up the chain of command.
I suppose that would be correct, yes, I think so.
To what extent did you talk to them about how SDS officers were being targeted?
We would discuss these things at the weekly meeting for a start, and informally in the corridors of power.
And how far up the chain of command would those conversations go?
DAC sometimes, but usually at commander level.
Did you ever get any pushback or challenge from them about the targets that were being proposed?
Not that I can remember.
Did you get any orders, directions, suggestions, or steers as to where officers should be targeted?
I don't recall that, no.
Were you aware of the existence of high-level committees in government? First of all, the Subversion in Public Life Committee.
No, I don't think I was.
And the Subversion Home Committee.
No.
Was there any awareness that very senior officers were attending meetings with the Home Office and potentially the Cabinet Office about policing matters at a high level?
I assumed it was happening, but I can't remember what the case is now.
Including about subversion?
Including subversion, yes.
Did you get any feedback from such meetings?
Oh yes, if they thought we should know, we were told.
Can you recall whether any of that feedback ever influenced targeting decisions?
They would have affected targeting decisions, yes.
Can you help us with what fields might have been identified for penetration from those sources?
No, I can't.
To what extent were your communications up the chain of command recorded in writing?
If you had a formal meeting, it would be recorded, but the informal meetings, probably not.
And what was the relative mix of formal to informal?
A formal meeting would be the ones where you were summoned in to see the senior officer.
My question is not so much distinguishing between the two, but trying to get a feel for how much business was transacted formally and how much business was transacted informally.
Most of the business was informal.
To move to the topic of the use of deceased children's identities for cover legends by undercover police officers. Could we have up, please, 731061? Can we have page 14, please? This is a minute from a superintendent SBC to chief superintendent, and it's very hard to see the squad, but we think it's this is about S squad monitoring. Could we look at the text in the first two paragraphs, please? The information contained at 36A and B suggests that Jeffrey Seed, a producer of the Channel 4 documentary 2020 Vision, MI5 Official Secrets, banned by the IBA a few years ago, is studying the feasibility of producing a television program which would compare intelligence activities in the late 60s, early 70s with those of the present day. In this context, Rick Gibson, the cover name used by Detective Inspector Richard Clark when serving as an SDS officer in the mid-70s, has again been mentioned and reference made to the fact that privacy may be able to supply Seed with a photograph of Gibson and some papers on the subject. Privacy, a 1976 member of Big Flame and the subject of RF Privacy, was the person who in late 1976 challenged the SDS officer about his identity and produced copies of the birth and death certificates relating to his cover name. This resulted in Clark's immediate withdrawal from the field. If we could zoom out to see the date, 26th of September is about 2 months before you started as head of C Squad on the 10th of November 1989. My first question arising from this is, did you know from any source that there had been an SDS officer, Richard Clark, who had been confronted with the death certificate of the child whose identity he had used?
I don't remember that now.
My second question is, can you recall whether it was drawn to your attention when you were head of C Squad that S Squad were monitoring the potential for there to be a Channel 4 documentary in which an SDS officer would feature in that capacity?
I can't remember this ever being spoken about.
Is it likely that this was drawn to your attention?
Probably.
Can we take it that you didn't take, whether or not you were told, you didn't take any steps to change the process during your tenure as head of C Squad?
No, I didn't.
Can you recall whether or not you had any cause to consider changing the process?
I knew there was agitation for us to change, but I can't really remember it being officially coming to me as an inquiry.
Did you consider taking any action proactively yourself?
No.
If we could take that down now, please. Could we have up 745856, please? This is the witness statement of the officer we know as HN56.
I'm just looking up the name.
You tell me when you've got it.
Yep.
In the meantime, could we go to page 5, please?
Yeah. Yes, I've seen that now. Thank you.
Thank you. Could we have paragraph 26, please? Thank you. Undercover identity. My cover name was Alan Charles Nicholson, though I went by Nick. This was not the name of a deceased child. Most UCOs immediately prior to me created their cover identity based on a deceased child's details, as far as I know. I did not do so because HN 109, one of my managers, was changing procedures because of issues affecting the unit. These are discussed below. I created my cover name by HN 56 describes how he created his cover name. Were you aware at the time, first of all, that HN 56 did not use the name of a deceased child?
No.
Were you aware that HN 109 had concerns such as to cause him to give the advice to HN 56?
I'm not sure when I became aware of this, no.
Without going into details, can you tell us whether or not the SDS changed its approach whilst you were head of C Squad?
Not to my knowledge, no.
Can we take that down now, please? I'd like to ask you about your working relationship with HN 109. Could we have up, first of all, 30684, file 2, tab B101, sir? This is a security service note for file. It says that on Friday the 10th of November I accompanied the then F4 to MPSB New Scotland Yard to be introduced to the new head of C Squad, Detective Chief Superintendent Tony Waite. He had replaced Dave Smith, who had retired, with effect about 7th of November. Could we go to page 2, paragraph 5, please? In relation to Stephen Scott, it says, Waite then commented on the case of HN 95, an SDS agent withdrawn under a cloud. He expressed forcefully and vigorously his view that Scott would never have spoken out of turn about his work. He knew him well and profoundly disagreed with the judgment expressed by others within C Squad at the time, nor did he believe that Scott fabricated his reports. Could we go below that to the comments paragraph? Privately, the then F4 commented to me that it had been DI HN 109, current deputy head of SDS, who had been the main instigator of this judgment of Scott. Hence, it put Scott, HN 109, in a very difficult position vis-a-vis his new head of C Squad. I think you made clear yesterday your continued support for Mr. Scott. Is that fair?
That is fair, yes.
To what extent were you aware that there had been a significant falling out between HN 109 and Scott?
I was not aware of it immediately at the time, but I heard it. I don't know how I heard it now.
Were you aware of it by the time you assumed the post of head of C Squad?
It was when I was head of C Squad I did hear such rumours.
Did your differences of opinion about Scott cause any difficulties in your working relationship?
No.
Would it be fair to describe HN 109 as a disciplinarian?
I never thought it into these terms. No, he was just a reasonable officer. I can't remember him being smart in that. No.
In terms of attitudes to discipline, how would you compare your attitude with that of HN 109?
I think he was probably more easygoing than he was, but I don't see any great difference between the two of us.
We can take that document down now, thank you. In your witness statement, you tell us that you occasionally attended the bi-weekly meetings in the SDS safe house. Could you explain to us why you did so?
Oh, I just wanted to keep in contact with the men on the SDS, officers on the SDS.
For what purpose?
Gain intelligence and to see if they had any real problems that were affecting them.
How closely in touch with the SDS were you?
I'd be in contact with them on a pretty regular basis.
How forthcoming were the UCOs in your presence as a detective chief superintendent compared to as a detective chief inspector?
I think they were rather more guarded.
What did you do about that?
I just tried to be friendly.
To what extent do you think you were able to elicit what challenges the SDS was facing during this period?
I tried to help where I could.
My question was really driving at how well did you understand what the SDS was doing during this period?
I think I understood what they were doing pretty well.
And you were seeing a lot of their intelligence reporting, is that right?
I would have been on C Squad, yes.
In terms of other paperwork, you've told us when you were DCI, I've got the impression there wasn't very much being generated. Was that still the case when you were head of C Squad?
I think so.
Can I ask now about joining criminal enterprises? Were you ever involved as head of C Squad, to the best of your recollection, in advising or deciding whether or not a UCO should join a criminal enterprise?
I can't recall that now.
Can you help us with the system? Was doing so left to the discretion of the undercover officer?
Partly, they usually sought guidance in these events.
Were these matters discussed with you through the SDS chain of command?
They would have been, I think, yes.
Was there any threshold of gravity of offence that required more detailed consideration by senior officers?
The chief inspector would make his mind up as to whether I should be involved in those things or not.
Can you help us at all in broad terms where the lines were drawn in terms of gravity of offence?
No, I can't.
Can we take it from what we looked at earlier that something like fly posting would be regarded as trivial and you would not be troubled with it as a chief superintendent?
If one of the men had been arrested, I'm sure I'd have been told.
But in terms of committing the offence of fly posting and not getting arrested, is that something that would just happen and you would not expect to know about?
I would expect to know about it.
You would? And how often were SDS officers committing criminal offences?
Never to my experience, I don't think.
Are you sure about that?
As sure as I can be after all these years, yes.
And were questions of joining criminal enterprise dealt with orally or in writing?
In writing, I would have thought, mostly.
Can I ask you now about a specific SDS manager? Please do consult the key if you need to. It's HN86.
Yes. Yeah, I've got it. Thank you. I've seen it now.
How well did you know HN86?
Quite well, I think.
Did you ever hear HN86 betray any racist attitudes?
No.
Did he ever use any racist language in your presence?
No, he didn't.
Are you sure about that?
Not as far as I can remember. I can't remember him never saying anything like that.
Can I move now to a separate topic? Can we have up 22111? This is an intelligence report from an SDS officer, Andy Coles, dated the 26th of March 1991. It's about a UK defence company. Could we have a look, please, at paragraphs 2 and 3? Blank, a pacifist vehemently opposed to militarism, has recently set up a new anti-war group, the Blank. The group is based at his home address, Blank, and seeks to end the research, design, production and sale of weapons by a UK defence company. Blank intends to involve church and peace groups in what amounts to a personal vendetta between the company and himself, and to that end has produced a newsletter, Blank Briefing, which will be produced quarterly. Blank's major interest is in staging non-violent direct action against the company, and he has recently been arrested for acts of criminal damage against the head office of the company and against a product of theirs at Blank. He intends to continue in this vein, and his latest target is the company's office. The precise nature of his action is not yet known, but he is only too aware of the difficulty in gaining access to the premises. And if we could go down now, please. A copy of the spring 1991 issue of Blank Briefing is attached together with a copy of a leaflet produced by Blank regarding the Blank. Bearing that in mind, could we take that down now and have 30705 up? This is a security service note for file, dated the 16th of April 1991, so a couple of weeks or so later on. Could we have paragraph 2, first of all, to set the scene? HN86 volunteered the news that he had just broken within C Squad that their chief detective, Superintendent Tony Waite, was being transferred to the National Post Office at Heathrow and being replaced by Detective Chief Superintendent Bob Potter in a straight swap with effect from the 29th of April. So that's to locate it. It's right at the end of your first stint as head of C Squad. Could we now go over the page to paragraph 6B? 6B, report of Blank referred to Blank, a pacifist vehemently opposed to militarism who had recently set up a new anti-war group, Blank. He appears to be waging a personal vendetta against a UK defence company. He has recently been arrested for acts of criminal damage against their head office and against a product of theirs at last year's Blank. He now plans to target their Blank office. C, who had been passed the above report by F2, is asking for permission to advise the company as a List X firm in general terms of blank intention to target the office. Our understanding is that this is a reference to the intelligence in the report we've just looked at. Do you agree?
It would seem to, yes.
And if we read on, it says HN 86 wished to consult HN2 first and confirm whether he has been convicted of the above offence. If so, it will be on the public record. And if we scroll down to the footnote, HN 86 phoned back on the 17th of April to say that there was no problem in our passing the information on to the company, as it was fairly well known in blank circle of activity. See informed. As we understand it, what's happening there is the then DCI of the SDS, HN 86, is checking with his undercover officer, Andy Coles, whether it is safe to pass on the intelligence. The answer is yes, and so the security service is being authorized to pass on some information to a List X company to protect it from the activity we've just read about. Is that a fair understanding of the documents?
I believe so. From the document, that would seem reasonable.
And was intelligence used in this sort of way to protect List X companies from crime from time to time?
It probably would have been, yes.
Are you able to assist us with how frequently this sort of thing happened?
Not really, no.
Are you able to help us with whether intelligence would have been shared with List X companies for vetting purposes?
That I don't know.
Are you able to help us with whether intelligence to protect companies which were not on List X from crime was ever passed to them?
Not to my knowledge.
Is it something that might have happened?
I can envisage it happening, yes.
Could we take that down now, please? Could we have up 33514? This is a security service note for file, 12th of November 1990, signed by S. Remington. Went on to greater things.
Yes.
Animal rights. I drew on the points in your NFF on the 1st of November at the board strategy discussion on the 6th of November. We were asked to conclude our consultations as quickly as possible so that advice could be taken into account in the final paper. Could we go to page 6, please? This is a security service note for file after the October 1990 ACPO conference. It's dated the 1st of November 1990. That's a signature page. Can we dial back one to page 5, paragraph 4, please? The context for this is the question of where policing of animal rights extremism should sit. I'll give you a moment to look at that, but it's towards the bottom of the page, bottom of the paragraph, that I'm particularly interested.
I've read that quickly now, yes.
Well, I'll read out the specific bit that I'm going to focus on. Waite also mentioned that the pharmaceutical companies themselves were also running penetration operations. He did not have, or was not prepared to impart, much in the way of detail, but he said that these companies, who have enormous financial investments at stake, are using these means of gathering information on animal rights activists. It is clear that they are also exerting considerable pressures, both direct and indirect, on the police for information and action against the activists. Can you help us, first of all, with how did you know that pharmaceutical companies were running penetration operations?
I can't remember that now.
Is it right that you were aware that pharmaceutical companies were running penetration operations?
I must have been told that at the time.
Was there contact between Special Branch and pharmaceutical companies for the purposes of protecting them from the criminal activities of animal rights activists?
I think I can recall speaking to the pharmaceutical industries, some of the bigger companies.
And can you help us with at what level that exchange of communication would take place? Who were you speaking to?
It would have been heads of security, I would imagine. I can't remember now for sure.
And can you help us with the sorts of things that they were saying to you and the sorts of things that you were saying to them without divulging any sources?
No, I don't believe I can.
Perhaps I can put it this way. What were their concerns?
Security of their premises and any experiments that were taking place.
And what were you able to do to help them?
To make sure that any demonstrations outside their premises would be covered.
Were you able to give them any advance warning of non-violent direct action?
I believe so.
You go on to say that they were exerting considerable pressures, both indirect and direct, as recorded by the security service. Can you help us with what form that pressure took?
Not now, no, I can't.
Is it your recollection that these companies were very keen for the police to do something about animal rights extremists?
I think they would have liked us to, yes.
Did they offer you any assistance?
No, not that I can remember.
Thank you. If we could take that document down now, please. Can I ask for 26742 to be put up? This is a document from September 1990. If we could look, first of all, it's an SDS report from John Dines. If we could have a look at paragraphs 2 and 3, please. During the weekend of the 21st to the 23rd of September 1990, writs were served on North London anarchists Paul Gravett, Dave Morris and Helen Steele on behalf of the McDonald's Restaurant Group. To date, Andrew Clark and Jonathan Farrell have not been served with writs, but service is expected. The basis for the civil process by McDonald's is the publication and distribution of a fact sheet by London Greenpeace entitled "What's Wrong with McDonald's?" and all the aforementioned individuals have, at some stage, circulated what is claimed to be a libelous and defamatory document. Only Paul Gravett, however, was in any way responsible for its compilation, which has remained unaltered since its initial production almost 6 years ago. You were head of C Squad at this time. Would this intelligence have been brought to your attention?
Yes, I believe it would.
Can you recall that happening?
No, I can't.
John Dines appears to have been omitted from those who were the subject of writs. Can you recall whether there was any discussion within the SDS about avoiding John Dines' involvement in these civil proceedings?
I can't recall that now, no.
Might there have been?
It's possible.
The SDS had been reporting on London Greenpeace's campaign against McDonald's for some years by this point. You'll recall yesterday we looked at a document from the mid-1980s. Was there any contact between you and McDonald's when you were head of C Squad?
I don't recall any, no.
Might there have been?
It is possible.
Given that McDonald's was the subject of some non-violent direct action, is it likely that there was contact between Special Branch and McDonald's?
It is possible.
Are you able to help us with whether or not McDonald's indicated to Special Branch before issuing the writs that it was going to do so?
No, I don't.
Are you able to help us from your memory as to whether or not McDonald's were aware that Special Branch had a source within London Greenpeace?
No, I don't. I didn't. I can't remember that. I don't think so.
Did you have any contact with McDonald's solicitors, Barlow, Lyde and Gilbert?
Not that I can recall.
The inquiry has seen intelligence reports from John Dines in which there is reference to the legal advice which Dave Morris and Helen Steele received at the early stages of this litigation. Can you recall any of that crossing your desk?
No, I really can't.
Is it likely that it did so?
It's probable.
Would the fact that one of the SDS's officers was reporting on legally privileged advice have rung any alarm bells with you at that time?
I think it probably would have done.
It didn't when you were the DCI of the SDS, as we went through earlier in your evidence. Why would the answer be different as head of C Squad?
We must have thought about it again, and I can't answer the question further than that.
Are you able to assist us with whether or not you did anything about Dines' reporting on privileged legal advice relating to the case that became known as Mac Libel?
Apart from that, the normal circulation to the security service, no, I can't.
Can we take that down now, please? Special Branch had an industrial desk, didn't it?
Yes.
To what extent did you have contact as head of C Squad with the industrial desk?
It's no longer as active as it had been, but we used to keep in contact with the industrial section, who provided useful information about the movement of extremists.
And was the industrial desk in contact with industry?
Yes, I think they were.
And subject to security considerations and source protection, would they have been communicating at least some information to industry to protect it from the activities of extremists?
I would assume so, yes.
Can you help us with whether or not this extended to the identities of extremists?
I don't think we would tell them, no. I don't think we would be telling them about extremists. No, not identifying them as an individual, no.
Why not?
We didn't feel it was our duty to do that.
Can you recall what rules pertain to doing so?
No, I can't.
The inquiry's understanding is that was officially prohibited. My next question to you is, do you have any understanding as to whether unofficially members of the industrial desk were in fact supplying the names of extremists to industry in order that they could avoid employing them?
Not to my knowledge, no.
Can I move now to the question of the relationship between John Dines and Helen Steele? Is it right that you would have seen surveillance photographs which included photographs of John Dines whilst he was undercover?
I'm not aware of that, no.
Is that something that might have happened?
Might have done, but I have no recollection of it.
What was your understanding of how close John Dines had got to Helen Steele?
I didn't know anything about them being close.
Did you understand that Helen Steele was a prominent activist?
I knew of Helen Steele, yes.
And you knew that John Dines was seeking to infiltrate the ALF?
Yes, I knew that.
And that Helen Steele would be a person of interest to the police for that purpose?
Yes.
Would you have expected John Dines to get close to Helen Steele?
No.
I'm using the word close here not in a sexual way.
She was an important figure in the movement at the time, and I would have expected him to gain what information he could from her, yes.
And that would involve befriending her?
Possibly. I have no inclination of knowing when or what she did.
Did any undercover officer or manager from the SDS tell you anything about what John Dines was doing vis-a-vis Helen Steele?
No.
If you had seen surveillance photographs which either revealed or certainly showed that there was a possibility that John Dines was in a sexual relationship with Helen Steele, what would your reaction have been?
I would have been against it. Would advise him to break off the liaison.
Given your acceptance of sexual relationships undercover, would your action have gone any further than advice?
I think it would have done, but it's hypothetical. I never did.
And I'm afraid another hypothetical question, but if that advice had been ignored, would John Dines have been left to manage the situation himself?
I think if we'd have known of it and he didn't accept advice, he would have been withdrawn from the squad.
How well did you know John Dines?
Pretty well.
Did you meet him in the safe house?
Oh, yes.
Can you help us with how he behaved in the safe house?
He was just one of the officers. He was well associated with the other officers and with the senior management. He's a likeable, approachable man.
Could you help us with the sorts of terms in which he spoke of activists?
What was it? He did use an Australian slang word about extremists, but I can't remember what the word is now. I'm sorry.
Complimentary or uncomplimentary?
Uncomplimentary.
I beg your pardon?
Uncomplimentary.
Was he derogatory about the activists he was mixing with?
Not unduly.
You've qualified that with not unduly. Could you help us with what you mean by that?
I mean, he like every other officer on SDS would unburden himself occasionally on you and referring to his colleagues in derogatory terms.
Can I take it from that answer that being derogatory about activists was common?
Within the group, yes.
Would that have extended to comments about female activists?
I can't remember any such, no.
But not have ruled them out?
I wouldn't rule them out, no.
We now know that John Dines did embark upon a lengthy sexual relationship with Helen Steele. Would greater oversight have helped to avoid that happening?
I don't know. I would suppose so.
And it might have either deterred the relationship or led to it being stopped.
Yes, I think so.
Was the failure to exercise greater oversight something that you would accept exposed women, including Helen Steele, to more risk of being deceived sexually?
I'm not sure I understand the question.
Do you accept that a lack of oversight meant there was more chance of women being sexually deceived?
We did what we could within the number of officers we had. And you couldn't do give coverage where we didn't have officers.
But officers could have been regularly reminded not to do this, couldn't they?
It's not really necessary to keep on telling men not to have sexual relationships. They knew that it was against the rules.
And they could have been asked, couldn't they, whether they were having any difficulties complying with those rules to try and head off any problems.
They could have, yes.
So do you accept that more could have been done?
More can always be done.
You said in your witness statement that it was unlikely that such women would ever learn the undercover officer's true identity. No doubt at the time you thought that, but it doesn't make it all right, does it?
No.
Because a deceitful sexual relationship deprives a woman of informed choice, doesn't it?
I can't imagine a woman making a choice on that basis.
Well, if you are a far-left activist, whether or not the man you are sleeping with is a police officer is likely to be an important consideration, isn't it?
It would be, but then men do tell lies to women.
And when they do so as serving police officers, that is completely wrong, isn't it?
It is wrong, yes.
Now that you know that John Dines did deceive Helen Steele into a lengthy sexual and emotional relationship, do you still think that John Dines deserved his commendation?
Yes, I do.
Why?
He was providing good information. He was doing what he was sent there to do.
Does that amount to an assertion that the ends justify the means?
I suppose it does.
And that the rights of the women concerned are subordinate to the intelligence that was being obtained?
I don't think so.
Why not?
They were free. They made their choices.
But they were not informed choices, were they?
Not completely informed, no.
Can we have up now, please, 526796? We're moving to the question of John Dines's arrest during the course of the poll tax riots in early 1990. Could we have, this should be 5267961, bottom of page 2 going up to the top of page 3, please. Sorry, it's a minute sheet about it. Could we have the minute 3 on the left-hand page? Thank you. We discussed these matters. I've spoken personally to DAC Mainel 8 area, and he is aware arrangements have been agreed between us in the event that DS Dines, under his assumed identity, does not attend court on the 10th of April 1990 to answer the bail on the charges laid. Those arrangements will necessarily involve only one other person, Detective Chief Superintendent Ram, who is in overall charge of the investigations into offences arising out of the disorder on the 31st of March 1990. Even DCS Ram will not be made conscious of the real identity of Cadogan or MPSB connections. I have directed that DS Dines will not attend court on the 10th of April 1990, and I will personally supervise the necessary action that will have to be taken initially to protect Dines from legal repercussions and subsequently to cancel all records of Cadogan's arrest and non-appearance at court. court. I have fully briefed Chief Superintendent C on that action and given explicit directions regarding the personal safety of DS Dines and the protection of his undercover role. At present, DS Dines' role has not been compromised and he can remain in situ, but a close watch will be kept on the situation in case it becomes necessary to withdraw him. If you could scroll down. You will know that DS Dines received minor injuries during his arrest, but he has now recovered and no lasting damage is anticipated. I will keep you informed of developments. If you could scroll down to confirm the signature. That's from Commander Ops, Mr. Gunn, at that time. The background is John Dines has been arrested at the poll tax riot. Is that something that you would have been made aware of at the time?
I would have expected to, yes.
And the Chief Superintendent C referred to in this minute is you, isn't it?
I believe so, yes.
So can we take it that Dines' arrest was something that had gone up the chain of command, at least as far as Commander Ops, including you?
Sorry, yes.
Is it likely that the courts, in dealing with the poll tax riots, were running lists at which the cases of people charged with offences arising from the disturbance were appearing at court?
Not aware of such a paper, no.
I beg your pardon?
Not aware.
I don't mean a piece of paper, I mean the way the courts operated. They'd have a morning where people accused of being involved in the riots and committing offences were all dealt with at the same time.
I don't seem to have been that much involved with this, so I can't remember anyway.
I remember. Is it likely that when John Dines was going to appear, or would have been required to attend court, that he would have been doing so with other activists?
I would assume so, yes.
Is it likely, therefore, that if he didn't attend, as per Commander Gunn's direction, an application would have been made by the prosecution for an arrest warrant?
I really don't know.
Well, in what circumstances would the prosecution not apply for an arrest warrant for someone arrested in the poll tax riots who failed to appear in court?
I remember what the decisions were at the time.
Do you have any recollection as to whether or not an arrest warrant for John Dines was actually issued?
I can't remember any such warrant being issued now.
Is that just a lack of memory or an assertion that one wasn't issued?
It's a lack of memory.
Is it likely that the result of the course of action directed by Commander Gunn was that an arrest warrant would have been issued in the name that John Dines had given to the police, which was Wayne Cadigan?
I don't know.
Can you recall whether you or any of the senior officers you discussed this issue with gave any consideration to the fact that an arrest warrant might be issued in a false name and an application made to the court for such a warrant using a false name?
I think I can remember talk about such things, yes.
Can you recall what the thinking was?
Not really, no.
Would operational security have trumped other considerations?
It would, I think, with the squad, yes.
A separate and final topic. At any time, whether as the DCI or the Chief Superintendent of C Squad or otherwise, can you recall a government intelligence coordinator or inspector visiting or overseeing or auditing the SDS?
No, I can't.
Can you recall a gentleman with the name Jerry Warner?
No, doesn't mean anything to me now.
Same questions in relation to the S Squad surveillance team.
What's the question?
Do you recall a government intelligence coordinator or inspector visiting or overseeing or auditing S Squad or any other part of MPSB?
Excuse me, not to my knowledge, no.
Mr. Waite, you've been very patient with my questioning. That concludes this phase of the process.
Is it expected that the Rule 10 process can be done over the luncheon break?
I expect that it can be, sir.
Yes. We'll rise now until 2. There may be further questions asked of you, but they will be asked at 2 if there are any.
Right, you are. Thank you very much.
Thank you.